Hello, everyone. I want to talk about the eviction ban and the lawsuit that we filed a couple weeks ago and what's happened since then. Some really good news for really for everybody is that the eviction ban is ending on the 14th of August. Many of you know that already. It's very important relief for property owners and really gets everybody kind of back on track to where they were. After we filed the suit, we heard lots and lots of stories from additional landlords, not just the ones that were involved in the lawsuit, of people that were committing crimes in their property, assaults. And one guy assaulted with a hammer in his property, and the landlord still couldn't get him out because of the eviction ban. Other people that are retirees and need the income from their rentals couldn't make their ends meet for themselves. Other people trying to sell properties and they could never sell them because of squatters that were staying in the property long after they were supposed to. Just all kinds of craziness from good intentions of let's take a pause here during the pandemic, but it's created a lot of problems, and many of the tenants were still getting full incomes and whatnot and extra unemployment, etc. And that was the genesis of the whole lawsuit, were these tenants that were working the system for their advantage, knowing that there was no repercussions for it. So we're happy to see a new advance in that, and that the governor's lifted that ban for now. There's other issues still remaining in the lawsuit. But today I want to focus for a minute on this Landlord Task Force report. You see it's dated July 29th, 2020. This was the day after we filed the lawsuit, right? So we filed on July 28th. This report had been prepared to be disseminated on the 29th at the governor's weekly press conference. If you look at this report, and you can get it online through the governor's office, and you ought to if you're an investor, you can see, of course, at the bottom here that it was revised for the new eviction moratorium guidelines 2 days later on July 31st. So I think that's a powerful witness to what you guys did as part of this lawsuit and all the cooperation we've had. I want to thank everybody for that. A lot of things you're going to see in there mostly are about cooperation between landlords and tenants, trying to get everybody to work together in a difficult economic environment and stay in the properties if they can. Of course, I've always said that eviction is the last resort for a landlord. No landlord wants to evict a tenant because that just means they're losing money, right? And they're having trouble in a property. So eviction is certainly not what anybody wants, but sometimes it's necessary because a tenant can no longer pay or doesn't want to pay, or they've got a different circumstance. So you're going to see a lot in there about communication. You're also going to see a pilot program in, I think, Delaware County, where they're going to add some mediation as a pre-trial and pre-eviction method of settling a case. Mediation is when a lawyer who's been trained in mediation is kind of a go-between between both sides. They don't have any authority to settle the case, but they're there to help communicate. And probably 95%, 90% or more of all cases are settled through mediation anyway. So your normal case, your normal contract case or car wreck case or anything else out there is almost always settled through mediation. In the eviction scenario, the timelines are so quick that I'm curious how it's going to work out. But I think it's going to head towards where we were with the foreclosure pandemic that occurred when we had the financial crisis in 2007 and 8, and the legislature came up with this settlement conference system that allowed the parties to work together and try to come up with a loan modification. Now, loan modification is quite a bit different than the landlord-tenant scenario, because in a loan mod, of course, the debtor is the buyer and the owner of the property. The bank has only got a lien on it, and it's a 30-year commitment rather than a 6-month or 12-month lease commitment. It's a very different factual and legal scenario. But what happened in the foreclosure context is we started having these settlement conferences. At the beginning, they were very robust, and there was quite a bit going on and a lot of interplay and true negotiating of new settlement terms. And sometimes even judges got involved in it. But what happened ultimately over the years, and that's 12 years ago, 12 years later here in 2020, what we see is that generally we have a lawyer appointed by the court that has a docket of settlement conferences, and those settlements then are phone conferences really between both sides. A lot of times the debtor doesn't show up, or there's very little to do because there's no solution except for foreclosure, and it's just a matter of working its way through the system. And that's, totally appropriate. I think that's where we'll probably head with all this, because mediation is very expensive, and there's just not a good way to do it financially. I think it will be more effective in a settlement phone conference as well if we have a more formal process. As everyone who's been to eviction court knows, every judge I've ever seen or been in front of tells the parties at the beginning that they're free to negotiate out in the hallway, free to communicate, come to a deal, whatever they want to do. Of course, the court cannot be a part of that, but this is already a common, common sense approach, is trying to get the parties together to work it out, and they often do. And a lot of cases get dismissed because the parties bring their balance current, or they do work out something. So that's one of the main things. Another thing that you're going to see in this report, I think that's very important, is an affidavit that your property is not under the Federal CARES Act lending. So you don't have an FHA loan on your property or Fannie Mae or Freddie Mac guarantee. So the federal government has certain loan guarantees, and because of that, the federal government has its own eviction ban. This is what we did was the state ban only. So the report from the governor's task force has an affidavit that says, I'm a landlord, I'm filing for this eviction, and my property is not under the federal prohibition, okay? So that's kind of an interesting extra step. The affidavit's a one-pager or 2 pages. There's a lot of exhibits in here. I really encourage you to get into that report, read through it. It's 10 pages long, plus all the exhibits. And they'll be very helpful for you to understand what's going to happen. And there's a lot of guidance for the courts on how to handle, a caseload that's coming up. Is it going to be in person? Are they going to have remote hearings? Are they going to bring people into court by texting them and say, come into court now, you're up? Kind of like when you're at the, at a takeout restaurant and you're, is your order ready? Yes or no? Go in and get it, right? So a lot of good, very practical things in there, but the mediation is a big thing. The affidavit is a big thing that you're going to see. It's going to be new. So if you've filed evictions in the past, this is a new template that you're going to have to work with. So that's it. We'll keep you posted on whatever else happens with the eviction ban lawsuit in federal court, and we'll go from there. But I really appreciate all the support we've gotten from so many people around the country, really other lawyers that have helped us on this case, and all the feedback we've gotten from you as landlords and investors. So keep us posted. We're always happy to hear from you, and we appreciate working for you. Thank you.